Welcome to Off the Clock, the webcast of employment attorneys at Miller Johnson, where we discuss what is happening in the HR world and provide practical insight and advice. All right, welcome everyone who has joined us so far. This is Sarah Willey. I'm here with Tripp VanderWal.
Good morning, everyone.
And you have found your way to our special live edition of Off the Clock. Today, we decided to do something different for our Off the Clock recording. We are recording live because we had a topic that we wanted to talk about that we thought was so timely that we should just get together and record it live rather than wait to issue a recording later. So thanks so much for joining us. We are here to talk about the impact of the recent Dobbs decision on employers, and in particularly on healthcare benefit plans. And we're also going to talk a little bit about travel reimbursement, et cetera. For those of you who are here who haven't met Tripp, he is my fearless benefits colleague.
Fearless.
Fearless, that's exactly right. He's the one that I call when a client has a question and they use things like ERISA and qualified benefit plan and self-insured, et cetera. So he is our one of our in-house experts on employee benefits. And as you're going to hear as this conversation goes on today, this Dobbs decision is raising a lot of questions that are particular to benefit plans. So he's here to talk about that piece of it. So really today we're going to first talk a little bit. We're going to give an overview of the decision itself. We're going to talk a little bit about what that means with regard to state regulation, which just fair warning is going to scare the heck out of our audience, right? Because not because of necessarily what particular states are doing, but because of the patchwork of what they're doing and not doing and what that means for all of you.
And all this is very fluid right now. I mean, it's
yes.
What we say today may actually change tomorrow.
I mean, it may change before we're done with
yes.
before the show is over. Let's be honest. So yeah. And then we're going to talk about the impact of Dobbs on healthcare plans and related benefits. And then we'll finish up a little bit and talk about other employment issues that I think could be around the corner. And that you guys all probably want to start thinking about now, at least. Okay, so let's just dive in and talk about what Dobbs did. Prior to Dobbs, there were two U.S. Supreme Court cases in place that stated that abortion was a constitutional right based on the right to privacy. Okay, and the most recent case of those two cases is Planned Parenthood v. Casey, and that said that a woman has a constitutional right to decide whether or not to have an abortion up to the point of viability, okay, of the fetus. So since 1973 in Roe v. Wade and then 1992 in Casey, that has been the law throughout our entire country. And because that decision was made by our United States Supreme Court, that meant that states were not allowed to pass their own laws that were more restrictive than Roe or Casey, right, Tripp? So there was, for better or less, a large degree of consistency. We knew what the rules were. Mm-hmm.
And viability was generally thought of to be about 24 weeks, correct?
Okay. Yep.
I believe that was kind of the case. And obviously we've seen some other cases where states have tried to regulate before that. In fact, Dobbs was a 15-week viability analysis, I believe.
I see. Okay. And that's probably why it made its way up to the Supreme Court, right? Right, Tripp? Okay. So Dobbs expressly overturned their decisions, right, in both Roe and Casey. and said that they disagreed that the United States Constitution does not confer a right to an abortion. Okay. Now, there's a lot of confusion here, right? I've been talking to a lot of clients about this. So I want to be very clear. Dobbs does not say that a woman is not allowed to get an abortion, right?
Correct.
It essentially wipes the slate clean from a federal jurisprudential standpoint, right? There's no right and there's no restriction on a federal level anymore. What that means then is that each state is allowed to make its own laws and or amend its constitution with regard to abortion.
Correct.
Right. And so what that has also meant is that many states have had currently have laws on the books, Michigan being one of them.
Correct.
That they haven't thought about for a long time.
Yeah, for Michigan, 1931, and we'll dive into that here in a little bit.
Exactly. So they haven't thought about laws for a long time, and that's because when Roe v. Wade was decided, it preempted that state law. So it just sort of sat there for, in this case, decades. Okay. Mm-hmm. Also, states have laws on the books that said if Roe v. Wade is ever overturned, this law will be triggered and will come into effect. Correct. Right.
Correct.
And so I tell you what, Tripp, I spent some time this week reading through the state of the law in each state, mm-hmm. right? What each state currently says about abortion. And I'm not sure there's a match, right? I'm not sure there's many states that say the same thing. I think we got 50 answers here.
Yeah,
almost.
Exactly. And what I've done a little bit of the same thing that you have. And what I found interesting is while most states do have an exception for preservation of the life or health of the mother, mm-hmm. not all states do. Yeah. Some states actually, that is still outlawed, but it's an affirmative defense for the provider. Right. If the health or life of the mother is in jeopardy, that they provided it. But it would still be a violation of the law, but they can insert that as a defense if they were charged with violating that law, which I thought, and there are a handful of states that have that.
Right. Right. And so to be clear, when we think about what the law in these states could be, right? We have states that have both civil and potentially criminal liability, right? Mm-hmm. For performing an abortion. In other words, that law would apply to medical providers.
Correct.
There are laws in effect that could outlaw medications that could apply to pharmacists and pharmacies.
Correct.
And we have laws in place that talk about assisting a woman in receiving an abortion.
Correct.
Okay. So there's a spectrum of options for these state laws. And by the way, we'll get to it in a minute, but some states actually protect the right to abortion.
Correct.
Right. And so when we as employers think about our benefit plans and our other employment policies and benefits, it's so important to keep remembering that the answer is going to be different likely in every state.
Correct. And I think, just to kind of throw this out here, aiding and assisting with, I think that very much would include paying for an abortion. So if you have a group health plan that covers abortions and you pay for that, that could potentially trigger liability under an aiding or an assisting law. And Sarah, you brought up, now that we're in the 1931 law, right. Before we talked about, even if we, like the 1931 law here in Michigan looks like it just applies to providers, but you had brought up a great point before we started, maybe you want to share that.
Yeah. So let's talk a minute about what Michigan currently says, right? So before we dive into the other 49 states.
Yeah, right. We're going to be here all day.
Yeah, right. No. We're not really going to talk specifically about the other 49 states, but let's talk for a minute about what the current law is in Michigan then, mm-hmm. right? So as soon as Dobbs got decided, it actually, before it was decided, lots of people were thinking about what the law is in Michigan with regard to abortion. And the answer is there's this 1931 law, right, that's been in the books that bans selling drugs or engaging in other medical activity to produce an abortion.
Correct.
Right. So on its face, it appears to apply to medical providers, potentially pharmacists, pharmacies, et cetera.
Correct.
Okay. Governor Whitmer filed a legal challenge to that 1931 law. And she filed that when that opinion in Dobbs was leaked, right? Before it became official and it was leaked. So this litigation has been going on for longer than a few weeks. It's been going on actually for a couple of months. And as part of that litigation, the Michigan Court of Claims has issued an injunction barring enforcement of this 1931 law. Okay. That injunction doesn't bar the law itself, but it bars enforcement of the law. Okay. And you would think that that then would clearly resolve things for the time being. Actually, it hasn't, because a handful of local prosecutors, including here in Kent County, have taken the position that that injunction does not apply to them. So there's some uncertainty still as to whether healthcare providers can perform abortions or not. And as I said, some local prosecutors have affirmatively stated that they intend to continue to prosecute this 1931 law, notwithstanding that injunction. Now, as you mentioned, in the crime world, in the criminal world, there is a separate offense for aiding and abetting somebody to commit a crime. Okay, so there is also concern that actions that aid and abet a provider to produce an abortion in Michigan could also be criminal. And one example, as you said, could be a group health plan that pays for that benefit.
So exactly. So even though this law on its face doesn't seem to apply or have any impact on group health plans, potentially if you aid and abet, pay for someone to violate this law, there is potentially some liability there.
Right.
And this is, obviously this is very technical or academic right now because we haven't seen any of this, because since 1973, when Roe was decided, this law was basically couldn't be enforced. It was unconstitutional.
Right.
Now we will see how this kind of unfolds here going forward.
And interestingly, given the current state in Michigan, not only does Michigan have a different state of the law than other states, but different jurisdictions within Michigan have different prosecutors who are taking different positions on this, yes. on this. So there's, suffice to say, in Michigan right now, there's a tremendous amount of uncertainty.
Correct.
Okay. Now, the other thing I will add about Michigan that's quite interesting is we are a state that allows voters to both make law and change our constitution by ballot. It's actually really interesting. And our listeners may remember that that's happened in recent years, right? We legalized marijuana, for example, right? Remember that? That was a ballot initiative. And our HR folks will recall, I'm sure, that we passed this law called the Michigan Paid Medical Leave Act. That was also a ballot initiative.
Okay, I did not realize that.
It was. And we now have a ballot initiative as well with regard to abortion. And currently, right, so the first step is for a public interest group to create the initiative. In this case, the initiative is to amend our Constitution, which is quite interesting. It's not just to change the law on the books, but to actually change our Constitution. What that, of course, means is the legislature can't mess with it then, right? It's a constitutional right. The public interest group then has to get enough signatures to support the ballot initiative, okay? And in this case, they needed approximately 450,000 signatures. It's my understanding they got over 700,000 signatures to support the ballot initiative. Based on an article I read, it's the most ever.
And they're going through the process of verifying those.
That's right.
But I guess at this point, we probably expect that this would be on the ballot come November.
Come November, exactly. And it would be on the November ballot. And it's a straight majority. So if a majority of voters in Michigan vote in favor of the ballot initiative, the Michigan Constitution will be amended to provide the right to abortion. It basically matches, it is in line with the Roe and Casey decisions, right? So it sort of tracks what we knew to be the law 6 months ago. And if that occurs, then all of the uncertainty in Michigan disappears, quite frankly, other than fighting about exactly what the wording of the ballot initiative means. So that's the current state of the law in Michigan. This is just an example. This slide is an example of the patchwork, right? It literally shows the patchwork of what other states are doing. We've got, as I mentioned, a whole lot of states that have trigger bans, meaning laws that were previously passed contingent upon the overturning of Roe and Casey. And those laws come into fruition within a certain time period. Some are 30 days, some are 60 days, et cetera. Then we've got states that expressly ban abortion. Then we've got states with don't ban, but have other limits that could be enforced, et cetera, et cetera, et cetera. Okay. And beyond that, not only do we have these laws in the books, I will add many of them are in litigation. So there's some uncertainty about what courts will say.
Correct.
Okay. And there is also pending legislation, meaning states are also passing new laws, Texas being one of them, to further restrict the right to abortion, and or some states are quickly passing law to protect the right to abortion. Okay, so this is going to be an emerging, what each state is doing is going to change. And I will also say that Tripp and his team, along with the employment section, is of course tracking all of that and keeping track of what is happening in all of those states.
So at this point, I'm going to kind of talk about the benefit, specifically group health plan issues that the Dobbs decision will impact. And really, we're going to talk about two different issues. And one is whether or not your group health plan covers abortion, or you're going to cover abortion and what that means going forward. And then, of course, the second one, which we've seen a lot of publicity about, is there's a lot of larger employers that are publicly pledged to help employees travel if they live in a state that outlaws abortion, travel to a state if they need to get an abortion that allows it, and then reimburse those travel expenses. I've
seen a lot of traffic about those.
I have never thought a travel reimbursement benefit would be this big of a deal, but I've never talked about it this much, but here it is what it is. And here we are.
It's interesting. When I first read it, I thought, well, why didn't we think of that before? Because I can think of lots of situations in which employees have to travel to get medical care, go to Mayo Clinic, for example, et cetera. So
correct.
Anyway, we'll talk about that more in a minute. But yeah, let's talk about Tripp group health plans and whether and to what degree they can cover abortions.
Yeah. So I think what I found is interesting is I have clients that really don't know right now the specifics. They're trying to figure out what does our health plan cover with respect to abortion?
I have found the same thing when
because
I
they don't
asked-
know.
yes,
I mean, it just,
right.
this has been something that has now kind of bubbled up to the surface.
Yeah.
And I would say that most health plans cover medically necessary abortions,
Okay.
where situations where the life or health of the mother is in jeopardy. And that would be so, and I'm getting a little bit out of my lane here, because that to not do so would violate the Pregnancy Discrimination Act.
And that's a federal law.
That's a federal law.
Okay, so probably if there's states that try to restrict covering abortions that are medically necessary, there could be preemption or constitutional
Correct.
issues there. So
Correct.
most healthcare plans are probably do and will continue to cover what's medically necessary. Yep. Okay.
But then from there, I think it's more of a plan design issue. You may have plans that also cover those medically necessary abortions, but other ones that aren't, quote unquote, not. And again, I just want to start, maybe table set here a little bit. When we talk about elective abortions, we're talking about abortions that are potentially not medically necessary, not that it's cosmetic, and we have the other issues with covering cosmetic procedures. We're talking about maybe ones that are abortions that are not necessary in order to,
not required for health, but
yes, exactly.
Okay.
So we may have, other plans that will still cover non-medically necessary abortions, but limit, for example, the situations to rape and incest. We may also have health plans that just cover voluntary or elective abortions. Again, so I think it's every employer should, start investigating and trying to figure out what do they cover right now. And then in a very close second step is, as an organization, you have, I think, determining going forward what you do want to cover. Exactly.
With the understanding. And of course, we understand that this is an issue that people feel differently about.
Correct.
Right. And some organizations may want to design their plan to cover as much as they can.
Mm-hmm.
Other organizations have a different philosophy, a different culture, and they may decide we now want to limit what our group health plan covers, right? So I agree with you. The next step is, okay, given the change in the law, what does your organization want to do?
Correct.
Right? Okay, that all makes sense. I'm with you.
And as we will talk about in the next couple of slides, if you have a self-funded plan, you probably have a greater degree of flexibility in doing plan designs, especially if you want to cover voluntary or elective abortions. If you're fully insured, you may be a little bit more hamstrung, not only by the carrier, but by insurance laws in your state.
Okay. So what do you have? What do you want to do? And then I would imagine then you have to look at what can you do.
Correct.
And that's where we get to the state by state analysis.
And really what we're going to focus our time here on, because I think the issues, there's a lot more issues with group health plans that want to cover more than medically necessary abortions, because there's a lot of implications that go on there. First of all, what states do you have employees who are covered by your health plan? Where are they located? And can I just add that number is a lot bigger now than it was before 2020. Thanks to COVID, right? I mean, there's probably lots of folks that are on the line here that said, I only had employees in Michigan. Right. And then COVID hit, and now I have employees in states all over the place. Right. And I'm hearing a lot of employers really wrestling with this idea of equity. They feel uncomfortable having different healthcare benefits for employees because they live in different states. Correct. Right. So they're really trying to grapple with this idea that there are going to be now different rules, very different rules. In fact, polar opposite rules. For example, in certain states, if you've got an employee in Colorado versus Texas or Mississippi or Oklahoma. Correct. Yeah. The other issue is whether you're subject to ERISA. So most private employers are subject to ERISA, with the exemption being governmental and church employers. And the reason that is important is because employers that are subject to ERISA have the benefit of ERISA preemption. And again, the last point on here is whether your health plan is fully insured or self-funded.
Okay.
And again, that gets back to the ERISA preemption point, of which we'll talk about here in the next slide. So it's, ERISA preemption is also, I think a lot of people are aware of it. And this is another issue that's kind of percolating to the top, which I don't normally see in my day-to-day practice. But I am now much more. So generally, ERISA preemption will preempt any state law that basically impacts or relates to an employee benefit plan.
Okay, so let's back up and just
Okay.
so ERISA is a federal law,
Correct.
right? And when we say preempt, another word would be trump, right?
Yeah.
It trumps.
Trump.
For
I guess our
listeners
our Michigan audience who plays euchre.
Yeah.
I have found that once you get out of Michigan, euchre is not.
Yes,
is not
it's
as
a trump
popular.
card, right?
Yes.
Yes. So what we mean is usually a federal law is the trump card over a state law.
Correct.
Right. And so for these self-funded plans that are subject to ERISA, there could be an argument that the plan doesn't have to comply with the state law because it's subject to the federal
Yep.
ERISA law. Got it.
But of course, there's, ERISA
But not
preemption
so fast,
is a
right?
rule that's built with exemptions, right? So the first big one is what they call the savings clause. And ERISA will not preempt laws that regulate insurance, banking, or securities. Here, obviously, the one that we're concerned about is insurance. So if you are a fully insured plan, that plan will have to comply
I see.
with state insurance law. So let's say in Michigan, with this 1931 law, that the Department of Insurance and Financial Services determines that, hey, because of this law, insurance plans can't reimburse elective abortions. Then even if you as an organization want to, you will be hamstrung by that. You will not have the option to do that.
Okay, so if you're fully insured, don't get excited about your ERISA preemption argument because you don't have it.
Correct.
Basically.
Correct.
Okay, got it.
That is basically correct. You're
Okay.
right. And then here is the other one. So ERISA preemption does not apply to state criminal laws of general applicability. And this is frankly something that I learned recently because criminal law.
You didn't have to think about it a lot.
Criminal and benefits law didn't often overlap. So
thank you, Dobbs. Right?
Exactly. So it's not exactly sure what this means. So if you have, here's my best example. So let's go back to the aiding and abetting law. Let's say we actually have a law in the books that criminalizes aiding or abetting or assisting someone from procuring an abortion. Again, that would likely include paying for one.
Yes.
And so if it is a broad-based law that's basically prohibits or criminalizes anybody or organization from doing that, that probably is a law of general applicability, which would not be preempted by ERISA.
So, right.
Now,
okay.
Again, this would be an academic example because I do not think a state would pass this, but say a state passed a narrower law that said group health plans or health insurance in general cannot aid or assist or pay for someone getting an abortion. Then maybe we have an argument that that's not general applicability and ERISA would preempt
if it's a self-funded plan.
If it's a self-funded plan.
Subject to ERISA.
Again, if you were a fully insured plan, you probably couldn't have that coverage anyway.
Right.
So again, this is an area that we're probably going to see some litigation over. And frankly, I think states, as they pass laws that would prohibit or criminalize this behavior, will have this in mind and say we need to do it at a broader base. Otherwise ERISA preemption could apply, could circumvent our law that
they're going to design their law. Yeah. So big picture here, Tripp, what I'm taking away so far is every employer needs to be thinking about how Dobbs impacts their health benefit plan, and their analysis and where they land is going to be completely individualized because it's dependent upon state law and it's dependent on their plan.
Correct. Right.
So these two, there's a lot of factors under state law. There's a lot of factors unique to their plan, and they're going to have to look at it on a very individualized basis. There's no broad answers.
Which is
here
why we
that apply
can't
to
just
everybody.
tell you
Yeah,
what to
got
do
it.
on this webinar. You're going to have to work with,
But
you know,
these are
your
the
benefits
things,
counsel
yeah,
to
be
work
thinking
through
about.
these issues.
Yeah. Okay. Got it.
So how are these state laws going to impact group health plans? And again, in states that only prohibit the provision of abortions, probably not going to have a huge impact, except for the point that Sarah raised earlier. You know, again, the Michigan law doesn't seem to have any direct impact on a group health plan because it just simply prohibits the provision of an abortion, right? But there is that argument that if I assist you in violating that state law,
right,
maybe I am
aiding and abetting.
Even though we don't have a specific statute that prohibits aiding and abetting.
Yep.
Now, again, there are a lot of states, Texas being one of them, that are passing laws that do prohibit aiding and abetting or assisting in getting an abortion. And I think that can kind of break two ways. Either you can have civil liability for violating that statute or criminal liability. And the reason that distinction is important is if it's merely a civil law or a civil statute, again, that is likely to be preempted by ERISA. So let's say you have a state that imposes civil liability on aiding or abetting abortion, and you have a self-funded group health plan that covers residents in that state that covers elective abortions. If you pay for someone's elective abortion and the state tries to prosecute you for that, you would have a defense that law would be preempted by ERISA. Tweaking that a little bit, if states, which I think is probably more likely, criminalizes aiding and abetting, then we go back to that general applicability exemption from ERISA preemption,
ERISA, the preemption,
and maybe you lose that argument. So I think for employers who have self-funded plans that operate in different states and that want to cover elective abortions, I think the problem states are going to be ones that have general criminal laws that outlaw that.
And I think it'll be, just to add on to that, I'm not entirely certain how those states would prosecute a health plan.
Yeah, they would prosecute most likely the employer, right, or the fiduciaries of the health plan, which if you haven't named fiduciaries of that health plan, which most employers haven't, it would probably be, you know, the board or whoever had control over that. So, and again, I don't know how that would happen. It would be interesting to see. And
those people may not reside in that state.
Correct.
Right. Yes. So again, there's going to be a lot of ongoing questions and issues, et cetera. Correct. Right. So to your point, I agree that it's going to be easier for states to try to restrict self-funded healthcare plans from paying for abortions by using criminal liability. But I also think it's harder for them to prosecute against a health plan.
Correct.
Right.
Yep.
Particularly if it's,
you can't throw a health plan in jail, right?
No, you really can't. I mean, I suppose you literally could put the plan in jail, but I'm not sure anybody's losing sleep over that. Right.
Exactly.
So yeah, so it'll be really interesting, right? I'm thinking of a maybe Michigan corporation that has a handful of employees or a small operation in a state that's restricting abortion and has a law criminalizing it. And I'm thinking, I don't know how, we keep picking on Texas, but I don't know how Texas is going to come after the board of that Michigan corporation. It's
also interesting because one other thing I don't think we pointed out is some states, not only have they legalized the right to abortion, but they're safe harbor, safe haven states, right? Like California.
Yeah.
And so if you're a California organization and you have employees in Texas and they try to prosecute you, California has said, we're not turning extradite these people to Texas for prosecution.
Right.
So then we get a state by state battle.
It's really interesting. Yeah. So a lot to think about. Very interesting. Again, it depends a lot on what the organization wants to do, what their goals are, what their plan currently is, and what's really, really specifically the laws are of the states in which they have employees working.
Correct. So now we're going to move on to the second issue, which frankly, I have never thought of a travel reimbursement benefit being such a big deal, but here we are. And we're having organizations nationwide that are pledging to reimburse employees that need to travel to get an abortion. And so I think we're going to see an uptick in that. And I guess the question is what is that? What does that mean?
What does that look like?
Do?
Yeah, because I've been looking, I mean, it's all over social media, right? Particularly with regard to obviously larger employers are the ones that the announcements make their way to social media. And I've noticed some of them seem to be specific to travel reimbursement for reproductive health or abortions very specifically. Others seem to be saying, we now have a new benefit that applies to travel for any health reason. So I find that interesting, Tripp. Yeah, talk about that a little bit and what the difference is.
So I really think there's two ways you can do this. You can either do it under your health plan as a benefit that's added to your health plan, or you could do it as a separate carve-out arrangement. If you do it under your health plan, I think, you're fully insured. You're a little bit hamstrung by what the state law is going to allow and what your carrier is able and willing to do. Now, again, if you're self-funded, maybe you have a little bit more flexibility. You still may be tied to what your third-party administrator can do with respect to this. But this is not a completely new area. I mean, most people that have health plans will know that there is a travel reimbursement probably connected to the most common example is organ transplants, right?
Okay.
Because you can't just go to any hospital if you need an organ transplant. So in fact, sometimes the health plan will only pay for it if you go to what's called a COE or a center of excellence. And therefore, since you have to travel, they will reimburse, your travel expenses and potentially someone that needs to travel along with you. So it's not an unheard of type of an arrangement, but again, and we'll kind of get into this, we have employers that are going to be very specific and say, we're going to add travel reimbursement for just abortion, right?
Yeah.
There is some maybe problematic issues with that, which we'll cover. Other employers are saying exactly what you said and said, hey, for lots of different reasons to avoid some of these issues and maybe to package it a little bit better, because this is a very polarizing issue. We are going to say, hey, if you have to travel more than X amount of miles, 50, 75, 100, those expenses that you incur to travel for any medical care, we're going to reimburse you for. And then that way it gets away. Not only does it get away with some of the maybe legal challenges, but I think they can package that to employees and say, again, maybe the Dobbs decision was the genesis for the reason of doing this, but they don't actually have to say, we're going to go out and just pay for you to go get an abortion.
Right. That makes a lot of sense. Okay.
So again, I think, without rehashing everything, even if you want to have a travel reimbursement benefit, you have to go through that same kind of analysis that you did with whether you want to cover elective abortions under your health plan and determine whether that's going to be permissible. And we won't rehash all those rules here. This is actually an interesting, and Sarah, I'll let you talk about this because you wanted to add this slide, but this was a letter that the Texas Freedom Caucus sent to a very large nationwide law firm by the name of Sidley Austin. Once they learned that they were going to add a reimbursement benefit.
That's right. So this letter came to our attention. And primarily I wanted to share it because it's such a good reminder that employers need to be thinking about the laws of the states in which they have employees, not just with regard to their health plans, but with regard to all decision-making, right? So in this case, Sidley Austin is offering a travel reimbursement benefit to everyone who works for the firm. Sidley Austin is a international firm, really. I don't know where all of their offices are, but all over the country. And as part of that benefit, of course, they offered it to everyone, including their employees in Texas. Okay. I am sure there is going to be a legal battle here over the position that the Texas Freedom Caucus is taking. I'm sure there will be a legal battle over whether you can really restrict an employer from providing a benefit to an employee, like a travel reimbursement benefit, et cetera. I'm sure there will be lots of litigation over whether a state can restrict somebody from traveling.
That's a great point. I think, because that did come up in the Dobbs decision in some of the concurrences. Well, can a state try to extraterritorially prohibit their own residents from traveling to a state to get an abortion? I think that is rife with constitutional issues.
Well, travel,
but certainly paying for someone to go get there may actually, states may be able to prohibit that.
Yeah, and I'll just to that, the right to travel is a recognized constitutional right? Mm-hmm. So that's an issue. So I did want to share this letter, not for the purpose of implying that we agree or disagree with the Texas Freedom. I want y'all to understand that as you decide what benefit to provide and where, you may get a letter like this, right? And this is a politically charged letter. It's from politicians.
Yeah, and it's not from the whole legislature. It's from
exactly right.
The Freedom Caucus. So again, I don't think that this letter has any force of law right now.
Absolutely,
but it is a good indication of where certain legislators in Texas, where they're intending to go now that they can.
That's exactly
more
right.
freely regulate abortion.
Yeah. So as I said, I would want the people I talk to in the HR world and in the benefits world to know that if they offer this benefit and they offer it to employees in Texas and it comes to the attention of the Texas Freedom, their organization, the CEO, may get a letter like this.
Exactly.
Right. And so you need to proceed with that knowledge.
Exactly.
And make those decisions knowing that there's a risk that that you could become embroiled in a legal battle. And
what I thought was also interested by this letter is they've not only did they threat, if this is a 4-page letter, so we just gave you a snippet. This would be particular to a law firm. Not only did they theoretically threaten criminal prosecution, they said, we're going to disbar any lawyers that are licensed in Texas.
That's really scary.
Yeah, right. So
throw me in jail, but if we can't practice law anymore, Tripp, what's the point,
exactly. Right? And this is a presentation of all kinds of new issues, and probably the first and last time Miller Johnson will ever reference another law firm in a webinar, right?
That's right. Or maybe the Texas Freedom Caucus.
Yeah, exactly. So what are your considerations when you're going to offer a reimbursement benefit under your health plan? One issue that really quickly sprang to a lot of people's attention was, okay, if I only offer a reimbursement benefit for abortion, which is a medical benefit, does that violate the mental health parity and addiction equity?
Yes, I see we just got a question on this, so I'm glad you're covering it.
So mental health parity, we could go into a whole hour-long presentation on mental health parity very easily. I will not do that today for the benefit
Please
of everybody.
Don't.
But it really requires everybody, it requires parity in how a group health plan covers medical, surgical benefits on one side and mental health and substance use disorder benefits on the other side. Well, some people have a concern that adding just an abortion reimbursement benefit will violate this. I'm not totally there for 2 reasons. One, mental health parity is not a benefit mandate. It's more of a process mandate.
Okay.
And so if you can justify differences, then you are outside of the violation. And you could very easily, I think, say, hey, the reason that we've added this reimbursement benefit for abortion is these folks can't get this service in the state.
Yes.
They can get mental health substance use disorder benefits in this state, so we don't need to have a reimbursement benefit.
So you couldn't you frame the benefit itself to say it's only available if it is not possible to obtain the medical services within a certain mile radius or within the state or whatever it is. Okay.
The other reason I think that this maybe is not an issue is mental health parity. When it looks at parity, it looks at comparing treatment limitations, whether those be quantitative or non-quantitative.
Okay.
And so I think it kind of, to say that the offering a reimbursement benefit for abortions violates mental health parity kind of flips that analysis on its head, because we're not really looking at a limit. In order to get there, you have to say, by adding this reimbursement for benefits, this enhancement, that therefore is a limitation on the other benefits where we didn't add it. And I'm just not there yet. But I do have a lot of employers, again, like I mentioned earlier, that because of this concern are also saying, hey, we want to kind of put this issue to bed, not worry about it. And it also can help with our messaging. We're just going to we're going to add a reimbursement benefit for any medical services that you need to travel more than so many miles to get.
Yep.
And that is one way to address this. So if you're moving on to tax issues, if you're going to reimburse this under your benefit, it can be done on a tax-free basis, just like all other benefits, but there are limitations.
You got to follow those IRS.
Yep.
rules.
So if your mileage for an automobile, it was 18 cents a mile, but it went up.
It's probably going to go up again.
No, it went up. So it's actually a different limitation than the standard per diem rate, which I think, but as you folks may know, that went up effective July 1. So previously it was 18 cents a mile. As of July 1, it's now 22 cents a mile. Planes, trains, buses, prices must be reasonable. It's question what that is, but certainly I think an example with a plane would be, you're reimbursing coach fare or the lowest fare that you can get. Lodging is $50 per day, $100 if it's necessary to travel with a companion.
What decade are they living?
Yes, I think I don't know.
$50.
I don't know if I even want to see the hotel that you can stay in for $50 a day. But that's so if you go above these amounts, that's permissible. But you'd have to treat it as taxable wages.
Exactly. Got it.
Meals are generally not allowable unless they're provided in conjunction with a hospital. So if you're in the hospital, those meals are allowable. Okay. Now, most abortions are not performed in a hospital, so meals are probably not going to be reimbursed
on a tax-free basis.
On a tax-free basis, exactly. Great clarification. And again, I think, if you're this, if we keep going back to whether you're fully insured or self-funded, if you're fully insured, I think you're going to be a lot more hamstrung with state law and whether the insurer is willing to play ball. If you're self-funded, you have more flexibility, but is your TPA willing and able to administer these reimbursement benefits?
Okay.
So you can also,
and then you got to follow all of those scary things.
Yeah.
Right?
So, this is actually, we're going to shift gears a little bit. Now, let's say we don't want to offer it as a benefit in our health plan. We want to carve it out, a separate HRA health reimbursement type arrangement. That is also permissible. But if, the definition of medical care under both ERISA and the code,
it's going to be a separate.
Yes. If you're only reimbursing travel expenses that are necessary to medical care, you've probably created a health plan. Yeah. So you've got this whole list of
a lot of acronyms
that you need to go through. ERISA, you need
all of the acronyms.
Plan document, you need a summary plan description. From an ACA perspective, unless you want to do what we call this accepted benefit, which you can generally only reimburse up to $1,800 per year, you probably have to limit it to folks that are enrolled in your health plan.
Okay.
COBRA.
Ooh.
So if people elect COBRA, and then if you do as a taxable benefit, you're potentially, if someone terminates employment with you, elects this COBRA under this benefit and receives it, now we're potentially processing taxable wages to them even after their termination of employment.
Wow. Okay.
We talked about the taxability. HIPAA. This is probably any information you get in a reimbursement request is probably protected health information, which is, again, I think why a lot of employers that are thinking about this are looking at third parties to administer it that they can keep their hands off. Mm-hmm. Again, mental health parity. We kind of talked about that. HSA eligibility. So remember, if to be eligible for an HSA, you actually have to satisfy two requirements. One, you have to be covered by a high deductible health plan. And two, you can't be covered by any other health plan that's not a high deductible health plan. So that second requirement one is that people forget about. And this is probably going to be a health plan that's not in a high deductible unless you basically say, hey, we're not going to reimburse you for the travel until you've satisfied your minimum deductible under the high deductible health plan.
So lots to think about.
Yep.
Okay.
Now, I have had some informal conversations with the IRS. An attorney from the IRS has said, hey, if you do a taxable reimbursement, that probably is going to resolve your HSA eligibility
So
issue.
it might be better just to do it taxable. Okay.
And then, of course, if you do create a group health plan under ERISA, you do have the benefit of ERISA preemption. Again, we won't go over that, but we'll talk about potentially here, you may be able to set up one of these arrangements that's not a health plan, which may be attractive for a lot of reasons, but you wouldn't be able to necessarily benefit on ERISA preemption.
Got it. So what I hear you saying is employers who provide the travel reimbursement for medical expenses only, you can certainly do it, but there's a lot of things that they need to be thinking through. You're thinking about these all the time. They really do need to be working
Correct.
with benefits counsel to make sure
Correct.
that's done correctly. Okay.
So, and if you want to do this and get yourself out of creating a group health plan, because that removes your HSA eligibility, that removes all of the issues of the acronyms on the previous slide, then the question is we have to have it be more broad-based. But then I think the problem is where do we limit eligible expenses?
It sounds like it turns into vacations really quickly.
Exactly. Because I haven't talked to one employer that wants to reimburse employees vacation travel.
Really? That's
expenses.
a shame.
Yes, it's maybe things have changed so much in the last 2 years. Maybe we'll be there soon. So these are some employers are calling these like lifestyle accounts or personal expenditure accounts. And really
creative.
What you can do, I mean, maybe we don't want to advertise it's vacation, but basically we set an amount, right? $1,000, $500, whatever amount you want in a year. And you're just eligible to reimburse for travel expenses under that account. And the employer won't even necessarily ask you what the reason for your travel is. Now, again, if you want to do this,
I don't see this getting a lot of traction.
Yeah, I don't know. But again, I think that's, if you want to have this be more of a compensation practice, I think that's the difficulty thing. That's where the difficulty lies. How broad-based do we want to make this?
Right.
What are the expenses we want to reimburse?
Right.
And which ones are we not?
Okay.
But if you do this, you got to think of, again, now we have a taxable reimbursement arrangement. We don't have ERISA preemption, but you also have to think of your other wage-based costs that are going to go up with this, right? So unless we carve this out of our definition of compensation for the 401k plan, that's going to go in when you decide matching or profit sharing
and all of
contributions.
that stuff. Yeah.
What about workers' comp? Can we carve this out of our workers' comp, or will that make our workers' comp go up? And again, if this is a fairly nominal benefit, maybe it's not, maybe we aren't too worried about, but these are things that I think you have to think of.
To think about. Okay. So again, lots of interesting plan design.
This is really,
questions.
When that decision was leaked, which I think is the first time that's ever happened for a Supreme Court decision. I can't remember that happening before.
Oh, never.
I
think it's the first time in history.
People initially called me and said, what does this mean? And I thought, at first my thought was, it's not going to really impact group health plans at all. Most states are just going to limit the provision of an abortion. So you can cover an abortion, but if you happen to live in that state, you just won't be able to get it.
Right.
Boy, was I wrong as this started to unfold.
Yeah. As we're looking around the corner now, we can see the level of differences and uncertainty among states for sure in what health plans can do. Okay,
I will pass that back to you now.
We have the employment issues I want to cover are really just going to take a few minutes. We have a couple of questions I want to circle back. Oops, I just lost him. Here we go. Sorry to the audience. Okay. That I just wanted to cover quickly. One of the questions is, what is this distinction between a voluntary and an elective abortion? I think for the purposes of our conversation today, Tripp, we were just sort of using those terms interchangeably. Somebody's health plan might have a specific definition for either one of those. So I can't really give an answer to that. What I would say is look at your health plan and see if they define.
The way I use those terms interchangeably, and to the extent that it caused confusion, I apologize. But what I meant by both of those terms is an abortion that was not necessary to protect the life or health of the mother.
Okay. Next question. It's an interesting one. If a fully insured group health plan currently allows elective abortions. And I think they're assuming this is in Michigan only. Okay. So fully insured. So they're subject to Michigan law, which, as we've just said, is in a state of flux.
Correct.
Right. Should we just wait until the November election to decide what to do? And what I guess what I would say is the law is in flux. I've heard prosecutors say, there's a handful of prosecutors who have said they would enforce that 1931 law as written. I have yet to hear a prosecutor say they would go after a fully insured group health plan for paying for the cost of an abortion.
Yeah, I think that, and again, this is my opinion, but I think prosecutors right now are focused on going after the person that provides the abortion.
The provider of the abortion, and not the plaintiff.
Frankly, I think they'll have a hard, unless they get a court order that you have to turn over information that you've paid for this. I think arguably this is protected health information. You could say, we can't give this
I can see, right.
I mean, if they get a court order, I mean, the Department of Health and Human Services has issued some guidance on this that basically says, this information in connection with a group health plan is protected health information. Okay. But if you get a court order, you're going to have, you're going to turn it over.
Right.
I'm not too concerned. Again, if you have a plan that's, all fully insured plans, issued in Michigan are licensed by the Department of Health or Department of Insurance and Financial Services.
Yep.
So until we hear them say you can't cover those anymore, I'm not too.
And again, this is specific to Michigan in particular. Yeah, I agree with you. I think that's the practical advice I would give, which is a lot of what we do every day, right? It's the practical advice. I think I would say, look, you need to stay on top of this. Right? You need to understand whether there's any prosecutors in Michigan actually saying we are going to go after a group health plan for quote unquote aiding and abetting a violation of the 1931 law, in which case you're taking a risk if you're going to wait to decide what to do until November. That has not happened yet. Mm-hmm. And I don't think it will.
And I don't want to get off on a tangent here, but that question actually brings up a whole other can of worms.
Boy.
So what if we have a health plan that's issued, a fully insured plan that's issued in Michigan but covers folks in other states?
Right.
Generally, states will say, as long as it's complying with the laws, the insurance laws in the state of issuance, that's fine. But there are a handful of states out there that do try to what I call enforce extraterritorial. They try to impose their insurance laws on insurance plans issued in other states to the extent that they cover residents in those states. Frankly, what's interesting about this is the culprits of those are generally like California, Massachusetts, New Jersey.
Right.
What's interesting is, but those are probably the states that are more likely to codify the right to an abortion versus the other way. So if you had a health plan that didn't cover elective abortions and you covered someone in those states, would that potentially
it could have the opposite? This is the point. You got to know where your folks are. Okay, just one other question quickly. Are there any state laws on the books that currently have criminal liability for self-insured health plans? And what I would say is I'm not aware of a criminal law on the books that speaks specifically to a self-insured health plan. But what everybody needs to understand is that states do have laws on the books that make it criminal to assist in getting an abortion, and paying for an abortion, which almost certainly is assisting in getting an abortion.
Yeah, so that would likely be broad enough to wrap up not only a health plan that covers the actual abortion itself, but potentially even a travel reimbursement benefit. Yep. Now, keep in mind, to reiterate, I don't know of any states that have a law that specific that
talks to health plans specifically.
And if it's
pending in Texas.
And if it did, arguably that would not be a criminal law of general applicability. So you would have the ERISA preemption.
It could be preempted. Interesting. Okay. So that's all of our questions. I do want to talk just about a couple of general employment issues that I want our HR folks to be looking around the corner to anticipate. I really do think the benefit in the travel reimbursement piece is the most emergent thing that people are talking about. Those are the questions I'm getting now. First of all, pregnancy, Title VII pregnancy discrimination. This is federal law, Tripp, and it prohibits any employment action based on pregnancy, childbirth, or related conditions. The EEOC has clearly stated that that includes a woman's decision to get an abortion. So currently under federal law, you cannot discriminate against a woman. You can't fire a woman because she has attempted to or has gotten an abortion, okay? That means that's a protected class, okay? I think about the travel benefit through the lens of a discrimination HR concern, and I think, oh my goodness, so if I have an employer that's providing a travel benefit for this purpose, I'm now going to have people with that information in my organization, and it's a protected class, right? So I think that's another reason to think about using a third party to be administering that benefit. Okay, we don't necessarily want our managers, our leaders knowing that one of their employees is getting an abortion or has gotten an abortion because that's a protected class.
Well, and I think, not only to a third party, but maybe that's an argument for maybe more this broadband lifestyle reimbursement account, because you will have employees that may be very hesitant to to submit expenses, for reimbursement because they got an abortion. So you may have this benefit in place, but it may not be used by some people because they don't want to, it's obviously a very personal decision, and they don't want to be telling their employer about that.
Right. So this continues to be true. Many state laws also have similar laws. Okay. And then our audience knows I talk about the FMLA and the opportunity. So another issue to consider, the FMLA, okay? The Department of Labor has been very clear that they're going to do everything they can to advance their mission by empowering women using every tool we have after Dobbs. Remember, the DOL is the agency that enforces the FMLA. Employees can take FMLA leave for pregnancy and related conditions. They can also take it if they are incapacitated for more than 3 days and see a doctor twice or see a doctor once and get some sort of prescription. There is established case law and precedent that says getting an abortion can fall under the FMLA under either of those circumstances. So as abortion becomes more of a frequent, potentially more of a frequent workplace conversation, I expect to be getting the question, does the FMLA cover a woman who potentially needs to leave the state and get an abortion, or just to get an abortion? And the answer is, it's a medical procedure just like any other under the FMLA, and you got to determine whether or not it falls under the definition of a serious health condition. Okay. Interestingly, there is not a specific exclusion in the FMLA for doing something that might violate state law. PTO. For those states that broadly prohibit any person from assisting a woman in getting an abortion, arguably that would include not only travel reimbursement, but paying the employee, giving that employee paid time off in order to do it.
Interesting. Which again, could go back to, hey, I don't want to know.
Right.
Why you're taking your PTO.
Why you're taking your PTO, et cetera. I have had conversations with employers wondering about whether they should revise their PTO policies to say, hey, by the way, you can't take PTO to engage in criminal activity. We never really thought about that before. It kind of went without saying. And it's an interesting question, right? They're anticipating a potential defense if a state goes after them for giving an employee PTO to get an abortion. They're anticipating being able to say, well, we didn't know they did it, and in fact, our policy says you're not allowed to do that. So food for thought. And then, of course, we'll just leave everybody with to think about the inevitable workplace conflict over this issue, right? I do think the Dobbs decision is leading to lots of conversations, right? About abortion specifically. And that will certainly make its way back into the workplace, et cetera. And we need to be thinking about Section 7 rights. Some states do have a constitutional right to freedom of speech, even in private workplaces. Many employers are taking a look at their policies about how we communicate with each other at work, what's allowed and not allowed. Can we wear pins and logos to invite conversations, or can we not, et cetera. And that really, I mean, those conversations really largely hinge on the organization itself and what they're looking to accomplish, quite frankly. But I'm having a lot of those conversations as well. So, wow, we covered all of the questions. Thank you, everyone, for attending our first live show, but I anticipate that we may do Off the Clock live more as new issues arise. So thanks, everyone. And thanks to Tripp.
Thank you for having me.
Tripp obviously knows this stuff inside and out. So for those in our audience who have questions specific to benefit plans and want to know what they can and cannot do right now, reach out directly to Tripp.
Perfect.
Okay, thanks, Tripp.
Sarah.
Have a great day.